For orders to initiate an inquest into the circumstances surrounding the disappearance of Brian Odhimbo pursuant to the provisions of Section 385, 386, and 387 of the Criminal Procedure Code. The application was brought by Vocal Africa and Alvi Aoko Okello as the applicants against the Director of Public Prosecution, the Inspector General of Police, the Directorate of Criminal Investigation, and the in-charge Kenya Wildlife Services Nakuru National Park. The background is that Brian Odhimbo, a member of Fisher Folk community near Lake Nakuru, disappeared on or about the 18th of January 2025. Allegations suggest that he may have been forcibly taken into custody by Kenya Wildlife Service officers. Despite habeas corpus application filed in the High Court of Nakuru, his whereabouts remain unknown, raising concerns of state involvement or cover-up. The applicant submitted as follows: that the applicant through their counsel, Mr. Abuya and Wanjir, submitted the Section 386, 1D of the Criminal Procedure Code emphasizes on the inquest surrounding the disappearance of an individual who may or may not be dead in a situation where the disappearance is suspicious. They argue that Section 388 of the Criminal Procedure Code only suggests that the ODPP may direct the court to order an inquest. That an inquest is a judicial function, the courts act as an investigative role, and that the ODPP's role will not be prosecuting, pursuant to the provisions of Article 157 of the Constitution. On Locus standi, they argue that Article 22 and 23 of the Constitution deal with Locus standi, and everyone is permitted to approach the court for enforcement of human rights that is at risk of violation. Thus, the applicant approached the court under the said provision. On issue of res judicata, they argue that the matter was not res judicata in the view that the matter before the High Court concerned an issue of habeas corpus, whereas this particular application involves an inquest which has not been determined. They referred to several cases, that is petition by Mwangi versus ODPP, Rimakau, which I'm proud to say that this one was done by my brother, a principal magistrate, captured in the Kenya law reports. There's another one, Waweru versus Republic. But of course, on the doctrine of res judicata, they relied on the case of Mbok and Lota. The first respondent, through Ms. Sang, agreed with the applicants that an inquest is a judicial function. However, they argue that this is a statutory procedure on how an inquest. There is a statutory procedure on how an inquest should be conducted, which are set out in Section 388, 1 of the Criminal Procedure Code, and that the use of the word "may" in that particular provision is a discretionary upon the office of the DPP. The first respondent relied on the case of Ri Male, Pius Mukono, and of course Masood Salim. So according to them, the ODPP through Article 157 of the Constitution can initiate the provisions of Section 388 of the Criminal Procedure Code. They also, in buttressing the point, they relied on the petition of Francis Anyango Juma versus the ODPP. And lastly, the first respondent argued that the investigation into the disappearance of Brian Odhimbo is still going on and should be left to proceed towards its conclusion. The second, third, and fourth respondent, through Mr. Rotich, argued that the High Court, while dealing with the habeas corpus application, indicated in its ruling that the prosecution should take its course, and as such, the matter had extensively been adjudicated before the High Court, and the present application is res judicata. They argue that the court to exercise the doctrine of constitutional avoidance, and that the court should not interfere with other constitutional bodies in performance of the constitutionally mandated obligations. According to the second, third, and fourth respondent, the application is premature. So from the application and the responses received in the replying affidavits, the annexures, including the arguments placed before this court, the following issues arises to be addressed. One, whether the applicants have a locus standi, whether the suit is res judicata, and lastly, whether the application is merited and or violates the doctrine of constitutional avoidance. I'll start with Locus standi. Article 22, Subarticle 1 of the Constitution provides that every person has the right to institute court proceeding claiming that a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. Article 23 further empowers the court to hear and determine application for redress of denial, violation, or infringement of or threat to a right or fundamental freedom. I looked at the case of Mumo Matemu versus Trusted Society of Human Rights Alliance and 5 others. The court emphasized that importance of public interest litigation, widening the scope of Locus standi beyond direct personal interest to include broader concerns about the protections of human rights. Similarly, in the case of Patricia Mbote versus Republic 2020, KLR clarified that any person could bring forward a case under Article 22 supporting public interest litigation without the need for personal interest. Given the applicant's reference to human rights under Article 22 and 23, they appear to have appropriately grounded their standing in constitutional law, allowing them to approach the court even for broader public interest and or human rights concerned. The applicants therefore appear to have Locus standi to approach the court for enforcement of rights as allowed by the Constitution. On the issue of res judicata, to determine whether the present application concerning an inquest is res judicata, particularly in light of the previous matter involving habeas corpus application before the High Court, it is essential to explore the core principles of res judicata and the distinct process of habeas corpus and inquest proceedings. The doctrine of res judicata bars relitigation of issues that have already been solved by a competent court. So for a res judicata to apply, the following elements must be established. Number 1, same parties, that is the parties in subsequent proceeding must be the same or in privity with those in the original proceeding. Number 2, same cause of action. The issue or cause of action must be identical in both proceedings. And lastly, the final judgment or ruling, there must have been a conclusive determination on the issues by a court of competent jurisdiction. There's also the distinct nature of habeas corpus and inquest. So habeas corpus, the primary objective of habeas corpus is to determine whether an individual is being unlawfully detained. It addresses whether there is legal justification for continued detention and offers a remedy for unlawful confinement. Whereas inquest, on the other hand, is an inquiry conducted to establish the circumstances surrounding a disappearance and or death, particularly where it's suspicious or not immediately explainable. It does not address the legality of detention but focuses on fact-finding regarding the cause of death. In the current application, I'll look at the elements that I've just mentioned. Number 1, same parties. If the parties involved in both habeas corpus proceedings and the inquest application are the same or sufficiently related, this element might be met. But as stated, the parties who appeared before the High Court were Independent Medical Legal Unit and Elizabeth Juma as the petitioner, unlike in the current application where we have Vocal Africa and Alvi Aoko Okelo. Number 2, the same cause of action. This is the critical point where res judicata generally fails to apply. The habeas corpus application addresses issues related to detention and the legality thereof, whereas the inquest focuses on investigating a death. Each proceeding serves a separate and a distinct legal purpose. The third one is final judgment or ruling. Even if there was a final judgment in the habeas corpus proceeding, the determination there will not necessarily resolve the factual queries pertinent to an inquest. So given the habeas corpus dealing with unlawful detention and an inquest addresses the circumstances surrounding suspicious disappearance and or death, the course of actions are fundamentally different. Therefore, the present application for an inquest is unlikely to be barred by res judicata, since it addresses different legal questions and facts related to circumstances of suspicious disappearance or death, not the legality of custody. Thus, the present application is not res judicata. The third issue is whether the application is merited or it underpins the doctrine of constitutional avoidance. Section 386 1D and 387 of the Criminal Procedure Code typically assigns the magistrate the responsibility to conduct an inquest to determine the cause of death in cases where someone is missing and presumed dead. This is inherently a judicial function aimed at establishing facts not assigning criminal liability. As per the Constitution, the ODPP primarily has prosecutorial powers, including deciding on prosecution based on established evidence or finding, such as those from inquests. There isn't direct constitutional mandate for reassigning inquest to the ODPP, although findings from an inquest may be submitted to the ODPP for further action as required by law. That is 388. The doctrine of constitutional avoidance suggests resolving matters using statutory interpretation first before engaging constitutional questions. Since the criminal procedure provides for magistrates to conduct inquests, the courts may avoid constitutional deliberation unless there is a clear inconsistency or inadequacy in statutory provisions. The Constitution under Article 157 outlines the powers of the ODPP, emphasizing its prosecutorial role without explicitly mentioning administrative or investigative roles related to inquest. In the case of Republic versus Commissioner of Police, ex parte Phyllis Temwai Kipteo highlighted the judicial commitment to upholding constitutional rights, particularly the right to life and liberty. The court directed an inquest despite the absence of specific evidence against respondent in the disappearance case, underscoring the inquest are judicial in nature with critical implication for public interest and fundamental rights. Similarly, in the case of David Nyakwara Siago versus Republic, are enforced inquests are judicial inquiries aimed at revealing facts in an explained or suspicious circumstance without concluding on guilt, affirming this as judicial rather than prosecutorial duties. Given the statutory framework, inquests appear to remain judicial functions, with the indirect roles of the ODPP in acting on recommendation from inquests. Invoking constitutional questions should only occur if the current statutory measures prove inadequate or infringe upon constitutional rights, aligning with the doctrine of constitutional avoidance. Be that as it may, and on going through the ruling on the habeas corpus proceeding at the High Court, and the fact that the first respondent had already been engaged by the second and the third respondent with detailed investigatory details concerning the case, and noting that the submissions were placed before the floor in regards that a file had been sent back to the second and third respondents for review, and having extensively read the forwarding letter dated the 28th of January 2025 by the second and the third respondent, minding that the response letter from the first respondent returning the investigation file has not been availed before this court to confirm the seriousness of the first respondent in pursuit of the matter, this court makes the following orders. Number one, the second and the third respondents, under the facilitation of the first respondent, are directed to extend and review areas stipulated by the first respondent in their letter that has not been availed in court, if any, to the investigation, by extension incorporate the request as specified in the applicant's prayer towards their investigation. This comprehensive investigation is to be completed within 30 days from the date of this order. Number two, upon completion in one above, the second and the third respondent shall forward the investigation files to the first respondent within the stipulated period. 3. Upon receipt of the investigative file, the first respondent is obligated to review and evaluate the findings and formulate recommendation within a reasonable time. And here I mean reasonable time according to this court is 21 days, not more than 21 days, and they should act accordingly. Number 4, the respondents are required to keep the applicants informed of the progress of the investigations. Moreover, the applicant should be engaged by the first, second, and the third respondent to provide any necessary information, evidence, materials, and or witness pertinent to the investigations. And lastly, failure by the respondents to conduct any of the aforementioned orders or direction within the next 60 days from the date hereof, leave shall automatically be granted to the applicants to approach the court to proceed accordingly. Yes, the same shall be uploaded in the CTS in the next few minutes. Thank you.